My name is Kellie Rish, and I'm an Assistant District Attorney at Jefferson Parish in the Family Violence Unit. Today, we'd like to talk a little bit about Gwen's Law, the importance of Gwen's Law, and the importance of Gwen's Law and the appropriate bond setting to a domestic violence case. Code of Criminal Procedure Article 313 provides that a person can have a contradictory bail hearing when that person has been arrested for domestic abuse battery, violation of protective order, stalking, or any other felony offense that directly affects a person with regard to intentional use of force or threatened use of force on a family member, a household member, or a dating partner. The court has to have these Gwen's Law hearings within 5 days of the individual's arrest. When a person is arrested, the court determines the conditions of bond and also determines whether or not the person should be afforded a bond if there is a substantial risk of flight or if there's imminent danger to a person or the community, and the state proves by clear and convincing evidence that that those things occur. If the court does not allow a Gwen's Law hearing or provide a contradictory hearing, it is required to tell the prosecuting agency that it is not setting it for a contradictory hearing, and then the prosecuting agency can petition the court for that hearing to be held nonetheless. It's really important that these hearings be held in domestic violence cases. It's important to get the information about each of the cases to the court for an appropriate bond setting. The court looks at many different factors when it determines a person's bond. Certainly it looks at the seriousness of the offense, and as we know, there are a lot of domestic violence statutes that are misdemeanor offenses, but that misdemeanor tag can sometimes not convey the seriousness of the offense of the crime. It certainly doesn't convey the physical pain or the emotional pain that a victim experiences when these offenses occur against them. And so it is important to have an advocate in the court to be able to relay that information to the court. The handling of a misdemeanor domestic violence offense today could prevent a domestic violence homicide in the future. So it is incredibly important for that information to be provided to the court, even if it's just a misdemeanor offense that's being perpetrated on the victim. The court can also and is supposed to look at the weight of the evidence against the offender. The court can look at the previous criminal record of the offender. The court can consider the danger that the offender's release will have on any person or on the community as a whole. The court can look at whether or not substance abuse is part of the facts of the current case, whether that be alcohol or drug abuse. Typically we hear, and oftentimes we hear from victims that that he or she is a great person when they're not on drugs or when they're not using alcohol. And so we know that alcohol and drugs sometimes exacerbate these domestic violence encounters, and they are part of the information that needs to be provided to the court, not only for the victim's sake, but also to address those problems in regards to domestic offenders and the help that they may need if the case is accepted and if it goes into the court system. Provide them the opportunities for rehabilitation. The other thing that the court can consider is whether or not the person is already on bond when they reoffend. That's certainly a very important thing to think about. The court can also hear evidence with regard to any threats of the offender to harm himself or herself, because threats of suicide by an offender is a control mechanism that domestic violence offenders use. By saying that they will kill themselves if the victim reports. They use that to continue to maintain power and control over their victims, and it causes the victims to be scared to report the criminal conduct. We can also provide to the court any information we have with regard to threats of the offender to kill the current victim or any other victims in his past. We can also provide the court with information with regard to the escalation of the domestic abuse. It started as a domestic abuse battery. It is now exacerbated, and it is now a strangulation or a forced sex act or some of the other telltale controlling factors that we know that domestic offenders that exhibit, those behaviors that they exhibit, which are sort of red flags for repeat offenders. Oftentimes the victims fear when they report domestic violence that the person will just get a low bond and they'll just get out and be back at the house the next day. Why bother, because nothing's ever going to happen. No one's ever going to do anything about the criminal conduct. And a low bond will essentially make sure that happens. The Gwen's Law hearing affords the prosecuting agency an opportunity not only to tell the court about the current history between the two parties, the victim and the defendant. It also allows us to bring up information with regard to other victims of domestic abuse by this offender, and it allows us to provide sort of a full picture of what this individual is like, whether this is a one-off, one-time domestic abuser, or whether this person is a serial domestic abuser, and so that the appropriate bonds are set as it relates to each case on a case-by-case basis. In Jefferson Parish, we contact the victims within a day of the arrest of an individual. Contacting the victims at that early of a stage allows us to develop a rapport with those victims. It allows us to be able to build and support that victim, to give that victim confidence to continue forward with his or her desire to prosecute criminal conduct that is being perpetrated on them. It provides them with an opportunity to express their safety concerns, and so that we can express those safety concerns to the court, so that appropriate stay-away orders are given during those hearings. And it just allows us to be able to sort of bring in this victim, make this victim feel like they have a support system, and they can feel confident to continue forward with the prosecution and be cooperative with the prosecution, knowing that they're not alone. And so all of these things that we can bring to the court's attention, all of these things that we can do as prosecutors in the process of getting prepared for these Gwen's Law hearings, ultimately set the tone of the case and allow us to continue with a successful prosecution if that is going to be the course of that case, and have those the early moments of that case continue to be a very important part of what goes on in the prosecution of criminal conduct, specifically with domestic violence.